So make sure all the cases, all the pages are identified with a case name or case number. Make sure they're all legible, especially faxes. Faxes sometimes come in, you can't read them. It's got to be legible. It's got to be readable. And if you're sending by email, set your software to request a read receipt so you have proof that you sent it when we got it. Service of documents. Anytime you serve a document or file a document with the Board of Election Commissioners, it is your responsibility to make sure that your opponent is served with a copy of that document. And so there are strict rules requiring you to serve your opponent in a timely manner, and then on each document it has to be accompanied with a proof of service that sets out the time, date, and manner in which you served your opponent. At the very beginning of the process, at the first hearing, you will be asked to fill out an appearance form. And we have a copy of the appearance form at the very back of the PowerPoint document. That will ask for contact information, email addresses, fax numbers, if you wish to be served by those methods. And most people nowadays are fine with that. So if your opponent has indicated he is agreeable to be served by email or fax, you can do so. But then in your proof of service, indicate that you emailed it or you faxed it, as the case may be. There is a fallback method. If there's no other practicable method of service may be made by filing a copy of the document and an executed proof of notice with the board, and the board will hold the document for the individual to whom it is directed. You have to certify that you made a good faith effort to telephone your opponent at least 3 times with no less than 2-hour intervals, trying to tell them, you know, I just filed this document with the board. If you want a copy of it, you can go pick it up at the board. It's available there. With email and fax prevalent as it is, there's really no reason to do this. But it is still an option in the event that you don't have email, you don't have fax. Doesn't happen too often, but it's there. Subpoenas, I talked about subpoenas a little bit. I think I've covered everything there, so I won't rehash it. Request for review by the Electoral Board. Once you're notified what the decision or the recommended decision of your hearing officer is going to be, you can request in writing not later than 5 p.m. on the first day following notification of the hearing officer's recommended decision. You can file a request asking the board to review that recommendation. The board's decision to conduct a review is discretionary. There's no absolute right to appeal or have it heard by the board sitting as a 3-member board. There are some issues, for example, if the candidate files or neglects to file a receipt showing that they filed a statement of economic interest with the appropriate officer, I can tell you right here and now that that's going to be fatal. That's the one substantive issue I'll talk about, because it is the case law is well established that the failure to file a receipt for a statement of economic interest is fatal. It renders your nomination papers invalid. That's an issue that's been decided by the appellate courts ad infinitum, and that's not something that our board is going to hear again, because we have to follow what the appellate courts have ruled. So there may be issues that's an established precedent supported by case law, and there's no point in our board hearing the parties on this case because it's not going to change the outcome. But in most cases that are novel, the board does make every attempt to give notice to the parties to come in and be heard. And again, when you file that request, you have to notify your opponent that you filed the request, and it has to be accompanied by proof of service as required by Rule 16. There's no new evidence at this hearing. This is based just on the record that was established at the hearing officer level. So if you've got, new evidence, you hired Perry Mason. Perry Mason's not a good example. He's dead, isn't he? Sorry. But I remember watching those old episodes. Perry Mason, the last minute, would come in with surprise evidence. We're not going to hear that evidence. It all has to be put in front of the hearing officer. And we're not going to entertain any new evidence. The request to be heard by the board is not jurisdictional. In other words, if you don't file a Rule 20 request, as we call it, it does not impair your ability under the statute, your right under the statute, to file for judicial review in the Circuit Court of Cook County. So you can go directly from the hearing officer up to the Circuit Court if you so wish. Okay? The decision, all of the decisions of the board are reduced to writing. It may be that during a, say, review of the hearing officer's decision before the board, they may have a discussion, and as a result of the discussion, they will take a vote as to whether or not to sustain or overrule the objections. That vote must be followed up with a written decision. And there's a new law that requires that any written decision be deemed served on the parties at the hearing. So we will serve you right then and there. If you're not there, then we can make arrangements to have the decision personally delivered to you, which not probably the preferred method, but the other option is to put it in the mail, postage prepaid, addressed to the last known address that we have on record for you or your attorney, and we'll put it in the mail. But you're deemed served at that time. So there's a risk of not getting that decision in hand. We have court reporters at all these hearings. Every hearing is transposed or transcribed by a court reporter. We prepare the transcripts for the board. If there is a petition for judicial review filed with the circuit court, we will prepare the transcripts and all the other evidence and all the other materials related to that proceeding, and we will file that record of proceedings with the circuit court. Ordinarily, we do not issue or make available copies of transcripts. So if you have a hearing and you're interested in getting a copy of the transcript, you have to call the court reporter and make arrangements to get your copy of the transcript. And you more than likely have to pay the court reporter for that transcript. We do not release copies of the transcripts unless and until we file the record of proceedings with the circuit court in the event of a judicial review. If you decide, either side decides to file a petition for judicial review, you have 5 days after service of the decision to file with the Circuit Court of Cook County. 5 days. That's a change in the law. Used to be you had 10. Now it's 5 days. Not calendar days. I'm sorry, not business days, calendar days. 5 days. When you file, you have to file your petition with the circuit court clerk. You have to outline the points as to why the decision of the Electoral Board was wrong and should be reversed. And you have to serve your opponents with a copy of the petition. And if you don't do all of those things, the court doesn't have jurisdiction, and they won't hear the case. Apparent conformity. Now, I mentioned at the beginning that there was still a way that your name may not be printed on the ballot, even if no one filed an objection to your nomination papers. And this can happen under what we call the doctrine of apparent conformity. Because if you recall, Section 10-8 of the Election Code said that nomination papers being in apparent conformity with the requirements of the code shall be deemed valid unless an objection is made. But the courts have said that even in the absence of an objection being timely filed, the election official with whom the nomination papers are filed has a duty not to certify a candidate or a referendum in the case of a public question if the petition is not in apparent conformity with the requirements of the code. The election official is charged with the duty of being a gatekeeper, so to speak, to make sure that frivolous nomination papers don't result in a candidate being placed on the ballot. We've had petitions filed by candidates or even petitions for a referendum where there may be a minimum signature requirement of 1,000, just to pick a number. And they file a petition sheet with 1 signature or 2 signatures. Obviously, they haven't met the minimum signature requirement. And sometimes this happens more often than not in referendum than candidates, but sometimes there's no objection filed. The doctrine of apparent conformity is designed to make sure that in order to get on the ballot, either as a candidate or a public question, you have to meet certain requirements, one of which being you have to have the minimum number of signatures. And if on the face of the document you don't have enough signatures, the election official, will not certify that candidate or that public question to the ballot. What we do, what the Chicago Board does, if we come to that conclusion, we will then provide written notice to the candidate. We're going to tell the candidate that under the doctrine of apparent conformity, your petitions are not in compliance with the law and you're not going to be certified in the ballot. And if you want to be heard by the board, you can come in and we'll assign a date to be heard. And you can come in, you can argue your case. But unless you come up with some really novel argument why you should be on the ballot, you're not going to be on the ballot if you don't meet the minimum requirements of the law, such as meeting minimum signature requirements. There may be other reasons for it. For example, for a candidate, you're required to file a statement of candidacy with part of your nomination papers. If you don't file that statement, you're not in apparent conformity with the requirements of the code. You're required to file a receipt for a statement of economic interest. If you don't file that receipt, you're not in apparent conformity with the requirements of the code. Anything that relates to the apparent conformity doctrine has to appear on the face of the document. We're not going to go into individual signatures to try to make a judgment as to whether or not that signature is valid. Any signature on the face of the petition is considered to be a valid signature. But if you don't have enough of them, you're out of luck. So this is based just on a visual examination on the 4 corners of the document. And if, based on that examination, you're not in apparent conformity with the requirements of the code, you will be notified, and you will be notified that your name will not appear, will not be certified for the ballot. Are there any questions about apparent conformity or any of the materials that we covered? Yes, sir.